Welcome to our annual Constitution Day event. I'd like to begin by thanking each of you in attendance today, especially our president, Dr. Jane Connolly, our provost, Dr. Brian Jersky, and the dean of the College of Liberal Arts, Dr. David Wallace. Your presence here, yes. Your presence here tonight signals your interest in and your engagement with our nation's most vital document. The Constitution's always mattered. It's been a guide, a touchstone. Sometimes it feels like a leash, and often we use it as a Rosetta Stone for figuring out what to do next. So the Constitution's always mattered, but perhaps you're like me and feeling like our own times right now feel especially freighted with constitutional significance. After all, you're living through the age of WikiLeaks and Citizens United, an age of global surveillance, local, historic levels of unrest, an age of corporate personhood, an age of safe spaces, of stop and frisk, and even press blacklists from political candidates. In the near future, the Supreme Court is expected to make decisions about the rights of citizens to make disparaging and even profane remarks about law enforcement, about the significance of place in determining whether threatening speech is protected by the First Amendment, and about the right of school boards to segregate bathrooms on the basis of biological sex. And that's just the first three issues that came to my mind. There's so much happening right now. Each of our presenters tonight bring their considerable expertise to help sensitize you to some of the contemporary issues related to the First Amendment and to the Constitution more generally. Now, this is not legal advice. They're not here to tell you how to go about your daily affairs, but they're here to invite you to think more, to engage more deeply, and learn about the most important document guiding our nation. Our first speaker this evening is an associate professor in the Department of Communication Studies here at Cal State Long Beach. His work frequently attends to public address, political controversies, and the First Amendment. He's the chair of the Freedom of Expression Division in the National Communication Association, and he's the director of Cal State Long Beach's Center for First Amendment Studies. Ladies and gentlemen, Dr. Kevin Johnson.
So thank you for being here on this occasion for our annual Constitution Day event. For those of you who have attended in the past or who have seen me speak on Constitution Day, you know that I usually offer a really detailed and deep kind of analysis of a current controversial issue concerning the First Amendment. Today I'm going to take a slightly different approach. What I'm going to do is I'm going to kind of take the shotgun approach and share with you kind of a lot of the issues that are on the radar of the Center for First Amendment Studies, some things that we've been paying attention to as their ongoing developments in the First Amendment. So without further ado, let me dive into them. Issue number one, Donald Trump and the First Amendment. Donald Trump has stated that he wants to, quote, open up our libel laws, end quote, to make it easier to sue media and win lots of money. Trump has a history of filing strategic lawsuits against public participation, SLAPP lawsuits for short. If you don't know what SLAPP lawsuits are, they're lawsuits that are filed against people for exercising their First Amendment rights with the knowledge that filing the lawsuit itself is the penalty, is what makes it hard on them, because they have to now pay the legal defense fees in order to defend themselves in court. So states like California and Nevada have fairly strong anti-SLAPP laws, but not so in other cases. And Donald Trump recently lost an anti-SLAPP lawsuit. So I think that we'll have to keep an eye on this. My biggest fear, as a side note with Donald Trump, is maybe a problem with the separations of powers, but maybe we can talk about that. We'll keep an eye on that candidacy as we go along. Issue number two, Hillary Clinton and the First Amendment. Hillary Clinton has endorsed a constitutional amendment to overturn the now infamous Citizens United decision. She wants to then basically change the interpretation of the First Amendment with a constitutional amendment to do that. In addition, WikiLeaks chief Julian Assange is also back in the news, claiming that Hillary Clinton poses a threat to freedom of the press. His reasoning is based on Hillary Clinton's stance on Russia and national security. According to Assange, Hillary is whipping the public into a neo-McCarthyist hysteria about Russia and turning the Democratic Party into the party of national security. He says that anyone opposing Hillary is accused of supporting the Russians, including Trump, WikiLeaks, Jill Stein, and Intercept, which is an American publication. So we'll keep an eye on whether or not there's a threat there with Hillary Clinton and the First Amendment. Issue number 3, Cocks Not Glocks. Texas passed a concealed weapons law that allows licensed gun owners aged 21 and older to carry concealed handguns in most places at public colleges and universities. A group of students protested the campus carry law by handing out free dildos to all students who wanted one on campus. So they were out there in the quad, parading them around. If you want one, come get one. The idea was to expose what they think is a crazy policy that allows a gun but not a dildo into the classroom. Texas professors, meanwhile, have filed a lawsuit claiming that concealed weapons limit freedom of expression in the classrooms because students and professors fear getting shot if they offend someone. So we'll see how that lawsuit goes, and we'll follow the case more closely in that regard. Issue number 4, the advocacy of terrorism on the internet. At the request of some members of Congress, the Congressional Research Service recently released a report about ways to limit the advocacy of terrorist acts on the internet. The report notes that it is very difficult to regulate the advocacy of terrorist acts. However, they did make recommendations about maybe some wiggle room in the internet being a unique communicative medium. They say that unlike other mediums, like face-to-face and broadcast television, the internet may pose a significant danger to the public due to the ease of propagation to people who might be willing to act on those messages. So we'll keep an eye on those developments following the report to see where it goes. Issue number 5, Citizens United is back in the news. The New York State legislature passed a bill in order to mandate that nonprofit charitable groups have to disclose the donors and contributors to those organizations, both in terms of the amount that they donated and the donor list. It went to the New York Supreme Court that ruled in favor of the New York State statute. So now they have to disclose their donor list, and undoubtedly we've not heard the end of that story. So we will see if there's any appeals that are filed with Citizens United as it impacts the way that we think about the mandatory disclosure requirement. Issue number 6, inflatable rats. That's right. The case began in Grand Chute, Wisconsin. A labor union displayed a giant inflatable rat and a cat that were strangling an inflatable worker. The display was placed at a cross street in front of a location where a non-union construction project was underway. The city asked them to take it down only after the non-union construction company complained. The union, in turn, sued, saying that their First Amendment rights were violated, and because it was selective enforcement of the law to ask them to take it down. The Seventh Circuit agreed that First Amendment rights were probably not violated in this particular case, but they sent it down to the lower court to figure out if this whole issue is moot anyway. And so that case is not done. Issue number 7, Stiletto Atlantic City. Atlantic City currently bans taxi drivers from attempting to divert customers to one business over any other, including suggesting that a customer go to one strip club over another strip club when they pick them up from the airport or something of that matter. Stiletto Strip Club decided that they would give tips to taxi drivers only after they would drop off people. So what happened was Atlantic City officials threatened to revoke Stiletto's business license for that pressure, diverting customers to one club over another club. And Stiletto has responded by filing a lawsuit in court saying that the city has violated their rights to commercial speech on that end, that they have the right to regulate the taxi drivers' business practices, but not whether or not the company itself gives tips to taxi drivers once they're already there. Issue number 8, Cake Wars. Jack Phillips owns the Masterpiece Cake Shop in Lakewood, Colorado. The bakery owner declined to fill the order for a cake intended for a same-sex union ceremony, and this then made it all the way to the Supreme Court. The Supreme Court is going to issue a ruling in this case about whether or not it constitutes discrimination or religious freedom of expression and religious rights. I'm sure that our own Professor Whitehead will have something to say about that as well. Issue number 9, police officers as public officials. There's a landmark case of New York Times versus Sullivan that might be reversed. or revisit it at the very least. If you don't know about New York Times versus Sullivan, you should look it up. It's pretty significant in our constitutional law. Essentially, there's a case called Armstrong versus Thompson that has been petitioned to the Supreme Court to argue that law enforcement officers ought not be considered public officials today because of the compelling interest that society has in protecting police officers' reputations. The other side argues that there's no need to revisit New York Times versus Sullivan, and we'll see if this case gets heard by the Supreme Court and whether there's a ruling. Last issue, Planned Parenthood's bill to punish undercover journalists. Planned Parenthood is pushing a bill in California that would punish undercover journalists for publishing and distributing recordings of private communication with a healthcare provider. Though the ACLU is often in support of Planned Parenthood, they are currently opposed to the measure because they believe the standard set forth concerning potential for real harm, that's what the standard is in the legislation, potential for real harm, the ACLU thinks is unconstitutional because the rationale would be used for punishing communications of other professions, including undercover journalism in law enforcement, animal testing labs, gun makers, lethal injection drug producers, the petroleum industry, and religious groups. So we'll keep an eye on that as well. In the end, there's a whole host of other issues that we're following, Terry Bollea and the Hulk Hogan case against Gawker, safe spaces on college campuses and the lawsuits involving Melissa Click at the University of Missouri, the American Bar Association's new verbal conduct policy, the Pennsylvania State Education Association case involving union expenditures, and many, 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 many more. So welcome to the exciting world of the First Amendment studies.
Our second speaker tonight is an associate professor in the Department of Journalism and Mass Communication at Cal State Long Beach. As a journalist, he's worked for BBC's World Service and for Transitions Online. He's interested in public opinions, in surveys, in public relations, and he teaches here courses on global news media, investigative reporting, and mass communication theory. His talk tonight is entitled Mass Media and the Constitution. Ladies and gentlemen, Dr. Chris Kharjov.
There are a couple of issues that I'm really very passionate about too, and they relate to the intersection between legal issues and the media as they are changing nowadays. I've started in the media when we still use typewriters. Can you believe it? I look young, but that's just and nowadays we have a completely different environment. And from the viewpoint of the laws, from the viewpoint of the constitutional issues, what happens in the United States, I can assure you, has a tremendous influence all around the world. So there are two kind of broad issues that I will try to touch on very briefly. I'm not a constitutional scholar, as I said, I have not been trained legally, but I have had quite significant professional experience as a reporter and as an editor. And one big change that has occurred between the time when I started doing media and nowadays, of course, has been the proliferation of the online media and how seemingly now everybody is a journalist, which is a good thing and a bad thing. When I was starting, I had to go and I had to have an editor to approve my article or producer to put me on air or whatever. Now I can start a blog. I can Facebook. I'm already a journalist. That's fine. That's good. That kind of lowers the entrance bar, but it creates some legal issues. For instance, in this country, we have something that's called shield laws that protect journalists from the need to reveal their sources. If they promise confidentiality to a source, there is a good reason to promise confidentiality. It is because some people just would not talk to you unless you promise them that you're not going to reveal their identity because they're fearful for their job, for their social status, sometimes for their life. So there is a good First Amendment rationality behind this, but then the law the laws as they're formulated in the 30 what 89 8 or 9 states that have shield laws, they say something along the lines of regular publication or magazine or other periodic issue. So, if I'm a blogger, am I considered publication? Am I entitled to the protection of this shield laws? Very interesting conundrum that has begun to be solved or addressed by the courts only probably about 10 years ago. There was one prominent case actually here in California when online, basically a blogger, published something about Apple. Can you believe it? 10 years ago, people were still interested in what Apple are going to do next, just as now. We just got the new iPhone, whatever, 777. So the court in California decided that there has been an intent to disseminate information, so this publication, basically a blogger, as I said, had the same protection as the New York Times would have, or the LA Times would have. Some courts have agreed with that. There is a case in New Hampshire that was kind of similar. But there are other courts, for instance, in the New Jersey court, that disagreed by saying famously that we should not confuse new media with news media. So that's an issue that has been sorted out. Who exactly is a journalist? Who can be offered this long-standing protections that have been granted to journalists in this country and to the mainstream media, not mainstream, to media, traditional media in this country for better part of maybe 50, 60 years since the shield law started to come into place. And then the other issue that is very interesting and very dear to me is online comments. I had a span of several years when I started my career in academia, going through the grad school and all that, when I was not publishing actively. So I would write a story here and there, but I was not an active journalist. So I jumped from basically mid and 90s when the only way to get feedback was somebody writes a letter to the newsroom. And then this letter, you might publish it, you might not publish it, you might hide it, you might, you do whatever you want with it, right? And then I jumped into 2006-ish. And I start writing a weekly column. And suddenly have this 200 comments, of which 199 are completely insane. And I was like, wow. And I had the stupidity to start trying to try answering all of them, or most of them, especially if they made an argument to me. And that's what I meant, which is completely, can't catch up with that. 200 comments. But then I became interested in the legal side of it, and it's a particularly interesting conundrum, because some courts have argued that, first of all, the publication can be liable or might be liable for the online comments. Not in the United States, but it happens around the world. So in the United States, we have laws, particularly that basically hold the publisher from tort, from liability for the comments, but they can be still pushed to reveal the identity of the commenter. In the European Union, where I'm coming from originally, I'm from Bulgaria, there's been very famous and chilling case, several years ago, when the highest court ruled that actually publications can be held liable for the comments. And this led, I saw this with my own eyes, this led to almost the extinction of comments in so many publications, because they thought, why go into the trouble of being sued for some dimwits with a keyboard commenting something on our wonderfully researched article, and then we get sued for that. So like 50% of comment sections just disappear. They shut it down. We don't want this to happen here. And in Europe, the battle still goes on. That's not completely settled. There's been a reversal of this. That goes on. But we don't want something like that to happen here. We value the comments. Comments are part of the freedom of expression, if you want. But there is a balance. And from what I read and from what I follow in the current legal environment is that there has been, first of all, the publications themselves are trying to shift away from completely online comments, and many large respected publications such as, for instance, the New York Times, they require you to sign up with your actual name, and some might require you to verify it through credit card information or whatever. So the comments are not completely just you come up with a nickname and there is no accountability, which again has its pros and cons because some people might not be willing to comment with their name. And another trend has been to look at the nature of the comments. For instance, there was a case in Plain Dealer, in Cleveland, Plain Dealer, when the newspaper voluntarily outed one of the commenters. When they found out that the commenter was a judge, a sitting judge, who was commenting on a case, on a court case that he was deciding at the time, which, of course, I would assume we all agree is highly unethical for a sitting judge. But the newspaper took this approach that because of the nature of this comment, they would basically voluntarily not fight any attempts to obscure the identity of this commenter. But again, this is an issue that has not yet reached the Supreme Court. I can promise you that within our lifetime, within the lifetime of our flowers, I don't know, it will get to the Supreme Court because it is something that, National Public Radio just decided not to have comments whatsoever because they was getting so distracting from the main conversation. So that's a First Amendment issue that Dr. Johnson did not mention, but again, as I said, hold me responsible for this. Within a few years, it will get to the highest court just because it's been a body of legal argument. Time's up. Body of legal argument that has been accumulating on different sides of this issue, and eventually there has to be arbitration at the highest level, and then we'll have a little bit more clarity.
Unfortunately, Judge Sanchez wasn't able to be with us tonight. She had other obligations that took her away. And that means that our final presenter tonight is an associate professor in the Department of Political Science and the director of Cal State Long Beach's Legal Studies Certificate Program. He holds both the JD and a PhD in political science. His areas of research include Christianity in the law, judicial philosophy, legal history, and critical legal theory. His address tonight is entitled Judges and the Constitution, Current Issues. Ladies and gentlemen, Dr. Jason Whitehead.
Thank you. I'm actually glad that I didn't research critical legal theater, because that doesn't sound very fun, actually. Theater should be much more creative than that. I'm also a little bit happy, don't quote me on this, but I'm a little bit happy that Judge Sanchez isn't here, because I'm going to talk about judges and the Constitution. And it's always a little uncomfortable when you have a judge in the room. Oftentimes, when we think about the relationship between judges and the Constitution, we have a picture in our minds about what a judge should do, about the character of the judge, about the way in which the judge goes about the task of legal interpretation, about the extent to which the constitutional text and precedent and other such things should bind the judge, and the extent to which the judge is free from those things. And I think really when we think about all of these issues related to the First Amendment, but in addition to the First Amendment, all kinds of constitutional issues that come to the U.S. Supreme Court in particular, but all federal courts for that matter, they work their way up from the district court level all the way up to the U.S. Supreme Court. When we think about current issues that arise in the federal judiciary, specifically with regard to the Constitution, the only current issue that I could really analyze for you, because I really couldn't get past it, because I cannot, normally what I would do is I would predict how the Supreme, well, I'm not a very good predictor actually, but I would try to predict for you how the Supreme Court would rule on a variety of current constitutional issues before the court. I cannot do that, and part of the reason why I can't do that is because of the only issue that I really want to talk about, which gets us into this larger question about the extent to which, how judges should actually approach the Constitution. And the current issue is the vacancy on the U.S. Supreme Court. We currently have 8 justices on the U.S. Supreme Court. You might ask yourself, if you are not sufficiently sort of keeping up with these kinds of stories, why are there only 8? Isn't there a possibility there might be a tie if there's only 8? Yes, there is. There are 9 seats currently on the Supreme Court. There are only 8 members because of the death of Justice Antonin Scalia. You might further ask yourself, isn't there a constitutional provision in place? Weren't the framers wise enough to anticipate that someone might leave office through some mechanism, whether it's death or retirement or something else? Yes, in fact, they did anticipate this. So many of you know, right, that the President of the United States is tasked with the job of appointing not only members of the U.S. Supreme Court, but all members of the federal judiciary, at least all Article 3, so-called Article 3 judges. And they're called Article 3 judges because that is the provision of the U.S. Constitution that deals with the judiciary, Article 3. So the President nominates members of the United States Supreme Court. But he nominates those members with the advice and consent of the United States Senate. The problem right now is, and here I can speak in my role as a political scientist, right? The problem right now is you have a divided government. You have a Democratic president who has nominated someone, Merrick Garland, an appellate court judge, to fill that 9th seat on the U.S. Supreme Court. And you have a Senate controlled by Republicans who is not willing to hold hearings on the nomination. So it raises the issue of judges and how they interpret the Constitution in a couple of ways. One is, what happens when you have a tie vote on the Supreme Court? Because the hearings aren't going to happen for several months at the very least. Even if Hillary Clinton gets elected, you would assume that she would either probably continue with the Merrick Garland nomination. Perhaps Garland, given the time considerations and other kinds of things, removes his name from consideration. You would assume that Clinton would pick someone similar to a Merrick Garland. Let's assume that happens. That confirmation probably would not take place. Even if the Senate were to shift to Democratic hands, the confirmation still wouldn't take place for a few months. So we're going to have some time to think about tie votes. What has happened recently with regard to tie votes on constitutional issues in the Supreme Court? To pick a couple of issues just off the top of my proverbial head, think about the Zubik versus Little Sisters of the Poor case from last term. This was a case argued before a very closely divided court. I actually had the good privilege to be at the Supreme Court the day that case was argued. You had very clearly 4 liberal justices who were arguing, who were essentially asking questions of the attorneys in ways where you could really tell which direction they were moving. In a very liberal direction. You had 4 members of the court that were asking much more conservative questions. That case eventually effectively did not get decided. What the court eventually did is they sent the case back down. And if you had a Merrick Garland replacing Antonin Scalia for that decision, my guess is that it would have been a 5-4 decision in favor of Zubik against Little Sisters of the Poor. The case is a very momentous case because it involves whether a religious organization can exempt itself from a generally and otherwise generally applicable law, in this case, the provisions of Obamacare that require the coverage of contraception. Whether a religious organization can exempt itself from Obamacare on religious grounds and say that effectively there is a religious exemption from participating in a law that most other employers would need to participate in. That's a very momentous question that did not get decided because of the lack of that particular justice. Without going through all the other issues on which it's problematic, all the other cases, we can talk about public employee unions. There was a major case last term that was decided a certain way because of the lack of a replacement for Justice Scalia. We could talk about affirmative action, another case that was decided, would have been decided differently probably if Garland had been confirmed, or for that matter, if a Republican nominee had been confirmed. But it raises the issue of the politicization of the judiciary, which gets me into the issue that I really want to talk about, which I'm using this as sort of an opportunity to talk about, which is the proper relationship between judges and the Constitution. So we typically think, I said, we have these pictures in our heads about what judges are supposed to be doing. We tend to have a couple of different images or a couple of different pictures in our heads about judges and the Constitution when we evaluate judicial nominations. One is our traditional picture that judges are the upholders of the Constitution, that judges are neutral, that they're objective, that they're principled in the way that they go about their decision making. And we all sort of at some level, all of the public opinion polling shows that at some level we buy into this. We all agree that this is the way that judges ought to be, and in many cases, depending on the survey that you pay attention to, people do believe that judges actually do this. The judges actually are objective, that they're not political, even when they interpret things like the Constitution. On the other hand, we have another picture of judging, which the nomination process really brings to the fore, which is that judges are political actors like anyone else in the political system. They are nominated through a political process, they are confirmed through a political process, and they interpret a political document. So how can we not expect them to be political? In addition to those political elements of the job, the nature of the constitutional text often, especially the First Amendment, but not exclusively the First Amendment, invites discretion. When we look at a phrase in the Constitution in the First Amendment that says that, for example, Congress shall not pass a law respecting an establishment of religion. Well, what does it mean to pass a law respecting an establishment of religion? When we look at the language in the Constitution saying that there is something called freedom of the press, what do we mean? What are the contours of that? When we look at the 14th Amendment of the Constitution, which says that liberty cannot be deprived, states cannot deprive citizens of liberty without due process of law. Well, what liberties? And what is due process? This is value-laden language that we're using. So how can that first picture of judges be accurate when we're talking about such a political process? I want to make a short pitch that actually the first picture of judging can be made accurate depending on the way that we examine the Constitution and depending more primarily on the way that we examine judges. So really quickly, there are different ways to look at judges when they interpret constitutional text. You can look at the text as an external measurement of how well the judge is doing in upholding the rule of law, in which case what you essentially would have is you would essentially simply look at the text of the law and examine whether or not the judge is sort of fitting their decision within the text of the law. The problem is, as I just told you, on many major constitutional issues, the text of the law doesn't decide the issue. The text of the law merely begins the debate. So how can you expect judges to be objective and principled when they're interpreting that kind of language? How can I make the case that judges ought to be principled? I think it depends on how you examine the Constitution, and it depends on how you examine the task of legal interpretation. If your view of the rule of law, and this is really what the Constitution, the whole topic of Constitution and judging actually brings into our consciousness, is the idea of the rule of law. If you examine the rule of law as a law of rules, then I don't think the first picture works very well, because the Constitution just simply doesn't work as a rule book. Ronald Dworkin, a famous legal scholar, once derided this notion of the Constitution as a rule book and said even though there are provisions of the Constitution that are relatively straightforward and clear, most of the key provisions that the Supreme Court must interpret are not so. So how can we, does that mean that we just have this politicized judiciary which doesn't uphold the rule of law, which is completely subjective and completely determined by politics? I think it doesn't have to be that way. I think that's the way that we've created it. That's the way we've sort of accepted it over the course of the years, especially since the 1980s, with the failed nomination of a guy most of you have probably never heard of named Robert Bork, who really sort of that was sort of the first shot fired in a long-running war between Democrats and Republicans over nominations to the Supreme Court and whether they would be consistent with the ideology of the nominating or the confirming political parties in the Senate. I think it's the wrong way to examine judges, particularly if we are concerned about the rule of law. So how can we examine the Constitution and examine judges in a different way? My preferred way of doing it, which I'll try to convince you of in 30 seconds, is that we should examine the values that judges bring to the table, not so much the political values that they bring to the table, but we should examine their professional values. That we should look more into the enculturation of judges, the socialization of judges. Most of the judges, frankly, that we nominate these days already have a track record. They've been judges for a while. Now, it's not required in the Constitution that judges actually have this background. You'd be surprised how few qualifications. There are actually no qualifications to be a federal judge except being nominated by the president and confirmed by the Senate. But there is a practice of judging. There is a profession of judging that lawyers can tell you a great deal about because they've argued in front of different judges with different values that other judges can tell you about. When we examine the values of judges, we're examining the subjective way in which judges think about their role, the way in which judges approach the legal language. So just examining the 14th Amendment. If you examine the 14th Amendment as simply the beginning of a political battle, I'm going to examine the 14th Amendment in a way that will help Democrats win this case, or that will help Republicans win this case, then I think it does actually undermine the rule of law. It undermines that first picture that we have a legitimate right to expect judges not to be upholding. On the other hand, if we look at the values of judges, if we look at the way in which judges examine text, and we find judges who actually take the text seriously on its own terms, but don't expect it to be a rule book, but instead expect it to be a source of principles, and look to precedents that have been established by prior courts, look to the tradition of constitutionalism in the United States. Try to look at the big picture of what a constitution is designed to do to begin with. What does due process mean? The language doesn't tell you much. But what has due process meant in the history of the United States? Now you're on to something. What should due process mean in light of the history of how it's been interpreted in the past? What should it mean in this case in front of the judge right now? Now we're at the level of being able to be a principled body where we debate the core principles that really tie us together and pull us apart as American citizens. And part of what we look to judges to accomplish is that task of deliberation that's very difficult to do in a democratic society, especially in a politically representative society where we expect our politicians to be representing every little interest that needs to be represented in the political process. Part of what we are examining judges for when we confirm them, when they're appointed and when we try to confirm them, is for those specific values of deliberation and their ability to bring those values to bear on the task of judging. So in any case involving freedom of speech, freedom of the press, or any of the other issues that have been talked about today, when we're looking at the next nominee, whether it's Merrick Garland or anyone else, I would urge people not to think so much about the political ideology of that justice and to look more into their political background, into their professional background, into the values, how they came to hold the values that they hold, into the way in which they have interpreted law over the years that may have run counter to their own political inclinations. Those are things that can be inquired into, that we can actually get more serious about actually choosing judges that uphold that first picture of the rule of law, maybe not so much in a slavish sort of textual way, but certainly in a way that we can still be proud of. So that's my take. That's my way of preaching about what I think ought to be the case with regard to the Constitution and judges. Thank you.
So we have plenty of time. You've heard messages tonight about just an enormous number of controversial cases from Dr. Johnson. You've heard a message about the media and the relationships between the media and the law and the protections that we hope will be there. You've heard about judging philosophies and about the potential nomination or maybe not of another Supreme Court justice. We want to encourage you to ask questions if you'd like to hear more from our presenters.
Has there been talk about who Donald Trump would appoint?
There has been a lot of talk about anything that Donald Trump would do, most of it coming from him. Yeah, he initially, when he was asked about the type of judges that he would appoint, he talked about his sister, I believe, who's actually a judge. And when it turned out that she's actually not a very conservative, at least for a lot of the political conservatives that are looking for a more conservative judge, he quickly sort of backpedaled on that and has said a lot of things about the types of judges that he would appoint to do specific things, right, to sort of reach particular ends, but it's a very instrumental kind of, seems to be, a kind of instrumental conception of judging to accomplish certain ends instead of interpreting law in a particular way. When he talks to conservative groups like the Federalist Society and other groups, or people from places that are more judicially conservative, he talks a good game in terms of, from their point of view, in terms of originalism, which is a particular way of interpreting the Constitution in light of the meaning that the people who wrote the language had when they wrote the language. But I don't get the sense that he has really studied these judicial philosophies. I think it's more instrumental. Like, I want to appoint people who will do the things that I want them to do, which frankly is not so different than the way that most presidents recently have appointed, all presidents of all stripes have appointed justices. And I think it's part of the problem.
Let me tack on to that, if I will. The other issue is that even if a president wants a particular type of justice, there's no guarantee that the justice is going to be the type of justice they want once they're appointed to the court. I mean, that's kind of how tenure works, right? And so we've had cases where I think, speaking to Professor Whitehead's point, is that when you have a president like George H.W. Bush, he didn't necessarily look at the judicial appointment as an explicitly political thing. In fact, one of the famous conversations that he had with now Justice Clarence Thomas before he was nominating him was to say to Justice Thomas, I don't want you to ever think that you have to rule because of any political pressure from the Republican Party. I don't want you to ever think you have to rule for pressure from me. My nomination is really about you being qualified for your commitment to the profession and things like that. So he kind of made that explicitly clear. What's interesting about that then is that George H.W. Bush also appointed Justice Souter. And Justice Souter ended up taking the bench and was known now as a liberal justice. He was in the 5-4 decision in Bush v. Gore. He had a long string of liberal kinds of decisions, even though it was a conservative appointee. And same thing with President Ford. He nominated Justice Stevens. Justice Stevens was in the dissenting part of Citizens United, right? So just because a president wants a particular type of justice on the Supreme Court doesn't mean that they're going to get that type of Supreme Court justice when they're on the court.
Can I just add one more thing? When you look at the overall statistics that correlate the party of the president and the party of the Senate at the time that the justice is confirmed, there is a pretty high correlation between their ideology and what justice and the ideology, if you could call it the ideology of the justice's opinions. But individual justices make a huge difference on a small court like this. And at key moments, especially since they're on there for life, the balance of the court shifts. So even though overall there is a high correlation, it's still a gamble. You put one person on there who's going to be there 30 years from now when that case gets decided that no one knows is even in the offing, that's make a big difference.
Yeah, even Justice Roberts surprised conservatives on a few occasions.
I mean, Chief Justice Roberts, what he's speaking to, he ruled in favor of the individual mandate in the Obamacare case. You know, I mean, how do you explain those things if you don't dig deeper into judicial philosophy in terms of the matching of different judicial philosophies as they match up to the Constitution? I don't know that a strict conservative or liberal framework works in those kinds of cases. There's more in play there.
You have a question over here.
So to tie a few things together, I think there's pretty widespread and even bipartisan opinion that Citizens United is a travesty. And so, but it seems like it would be inappropriate for, let's say, Hillary Clinton, if she were elected, to seek out justices that specifically say that, that they're opposed to Citizens United. That a better route is for her to actually seek out an amendment to the Constitution to overturn Citizens United. Does that seem right? Would it be inappropriate for her to say, I'm looking for judges who will overturn it?
I think so. I mean, I don't necessarily appreciate too much when presidents say this issue is the reason why we want a Supreme Court justice. Because the Supreme Court is way more dynamic than that. I mean, they get, 100,000 or something crazy amounts of petitions per year, and I think 15 of the, what do they hold, 160 cases a year? Like 15 of them are decided by 5-4, so most of them aren't even along the ideological lens like that to begin with. And so you're talking about a wider range of issues, which is why I think a candidate like President Hillary Clinton has advocated a constitutional amendment rather than having this kind of accusation of the activist judges doing this work to overrule precedent.
And also, don't be so certain that a President Hillary Clinton will be so eager on overturning citizens, right? Because we remember very well how Obama was saying that he's never going to use super PACs, and of course, the justification is why we use the super PACs is because they use the super PACs, and it becomes a little bit of a, chicken,
Although she has a personal relationship with Citizens United.
So-
right? So.
I don't know. I would not, hold my fingers crossed for that.
The other thing is that you can't just it's not as if the Supreme Court has the power to reach out and, find the appropriate case. It would have to be, the course of events would have to kind of lead the court to decide another campaign finance case, and it would have to be situated in the right way. But I want to maybe reframe it and say, maybe I'll take a bit of a different tack and say, if we change the case and ask, were judges bound, or should we have supported a president who said that the court should overturn Dred Scott, for example? You know what I mean? I mean, when the stakes get high enough, I don't think Citizens United is the same as Dred Scott, obviously. But when the stakes get high enough, I think it is legitimate to say this is such an unconstitutional decision that if, obviously, if it ever comes to it, that I'm going to use this as a kind of maybe a partial litmus test, because it tells me how committed the judge is to the underlying values that the Constitution is supposed to be upholding. And for some people, Citizens United is not so much at that level, but it certainly is that unconstitutional and that crazy in terms of its interpretation of the First Amendment. So I guess it does raise the issue of, are judges there to do right and wrong, to do justice on some bigger scale, or are they just there to kind of...
And that's a good case, because like the historical stuff, the rationale matters. And so you saw in that case, Justice Stevens and Justice Scalia going head to head on what the framers of the Constitution, how they would interpret it, which is a different kind of rationale to what is the impact of it today.
We have time for one more question.
Is it apparent that there's less political polarization in the Supreme Court due to the fact that there's not as many, like you said earlier, there's no party pressures, there's no external factors influencing them, and the position's more concrete? So is it found that there's less polarization actually happening in the Supreme Court compared to the rest of Congress, for example?
I think it depends on how you define polarization. Most of the research on the Supreme Court shows that over the last 20, 30 years, they've grown further apart. I mean, just in terms of like even geography, their chambers are not as open as they used to be to one another. they don't socialize as much as they used to. And partly that's a trend that all of us are probably facing as well. But I think in terms of polarization and the way that political parties have begun to use the judiciary, not begun, but have for many years been using the judiciary as another kind of political tool. That has an effect on the judges that get appointed and confirmed, and then has an effect on the kinds of opinions that get written. Even if it's not straight political lines, there is a kind of cantankerousness about the opinions now, Scalia being chief among them before his passing, that maybe you didn't see 30 years ago, 40 years ago, in terms of like going after the, almost the personal quality behind the opinion instead of just the logic itself. So some of that, I think.
2 minutes if we have more questions.
I was just going to ask, recently Ruth Bader Ginsburg made a critique of Donald Trump. I forget the exact quote, but I guess what do you think of that? And are Supreme Court justices that voice their opinion anything new in American politics?
I think one of the concerns of the judiciary is this kind of historical appreciation for separation of powers, and I think that what the Congress and what the Supreme Court and what the President interacting as different branches, I think that one of the things Ruth Bader Ginsburg is concerned with is not only the obvious liberal conservative kinds of issues that they would differ on, but the fundamental issue of the role of the court and the Supreme Court's role in the checks and balances itself. We have a history of a president, Andrew Jackson, who said, the courts have interpreted the law, now let them enforce it, and went forward and used the military anyway. So I think that what the Supreme Court, most justices are really paying attention is to this issue of executive powers in general as they've expanded, but more specifically when they hear things like the libel law stuff that is on the campaign trail and the executive powers to shut them down. If the Supreme Court says you can't shut them down and they go at it anyway, what are they going to do to enforce that rule of law? And so I think that the voice of many of the justices is really, a concern for electing a presidential candidate that respects the separation of powers.
That's all the time that we have, but you don't have to wait until next year if you found this interesting. You can always go to firstamendmentstudies.org, find out what the center is doing, and be more a part of our work here on campus and in Long Beach. Thank you very much for your attendance today.